Hi, I'm law professor Thaddeus Pope, and I want to talk to you about some brain death controversies. Specifically, I want to talk about the case of Archie Battersbee. Archie is a little 12-year-old boy. He's really good at gymnastics. He likes ice cream. But just a few weeks ago, back on April 7th of this year, Archie was engaged in an online challenge at home and apparently strangled himself. He was found by his mother and was taken to Royal London Hospital. He was comatose, unresponsive, and clinicians think that he in fact might be dead. So they do bedside clinical exam and now you think, yes, he probably is dead, and they want to do an apnea test to confirm that. But his mother says, no, I forbid it. You can't do the apnea test. So clinicians go to court and they ask the judge, we have a patient in our hospital. We need to know, is he alive or is he dead? It's a fundamental question. We need to know the answer. The court rules on May 13th, says, yes, the clinicians may test for brain death. Now, they're actually unable to do the apnea test, but they do blood flow tests instead. And of course, if there's no blood going to the brain, then there's no oxygen going to the brain and the brain has died. That's what they determine. But mom still doesn't accept it. The tests have been done, but she doesn't accept now the results of the tests. This goes back to the high court in early June, and the court rules on June 13th. And basically the judge says, yes, Archie is dead. The judge goes beyond that and says, you know what, even if he weren't dead, he's so catastrophically injured that it's not in his best interests to continue to get mechanical ventilation and other organ-sustaining treatment. Now, this determination was supported by the expert evidence from specialists at 5 different hospitals, and now, of course, that's all been subject to court scrutiny. Still, mom doesn't accept that. So, Archie is still there, still at Royal London Hospital, still in the ICU, and now it's been 83 days. He's been dead for all, or at least most of that time. And counting. Why? Because mom has sought an appeal, and the appeal has been granted. Now, the appeal is limited to just the evidentiary standard. That's the legal question for the appellate court, right? Appellate courts don't re-examine the facts. The question is, what evidentiary standard should the trial judge have applied? Should it be preponderance of the evidence, the typical civil standard, more likely than not, or should it be something more like the criminal standard, beyond a reasonable doubt? So that's the appellate question. But the issues that the family sought review on, these weren't granted, included, should the clinicians have gotten the consent? Did they need to get consent to do the tests in the first place? Should the court have considered Archie's religious views about brain death? Apparently he had formed and expressed some. Did clinicians administer the correct tests to ascertain, to evaluate brain death? And is brain death even a legitimate way to ascertain death? Now, that's a British case, but those issues, those questions, are not unique to the Archie Battersbee case, not unique to the UK. Those same questions have been asked in courts across the United States, from coast to coast and in between, and in courts in Canada. So I'm collecting these cases at thaddeuspope.com/brain death. Thank you.